My name is Janlee Wong. I have an MSW and have served as the Executive Director of the NASW California chapter since 1995. I have extensive experience in answering questions related to social work ethics, and I'm available for ethical consultations to social worker members in California. There are two overall goals for this demo course. The first is to provide viewers with an example of media-rich content found in the courses on this new website. The second is to provide a brief overview of the key considerations in determining how long practitioners should maintain client records. It's important that viewers understand the information presented in this course does not constitute legal advice. NASW recommends that clinicians seek consultations with an attorney prior to making legal decisions that affect their practice. Learning objectives. At the end of this demo, viewers will be able to identify key considerations in determining how long to maintain client records. They'll also be able to identify related NASW guidelines, the California Licensing Board regulations, and other applicable ethical and legal guidelines. And they will be able to identify other topics to pursue in terms of continuing education. I'm going to give you a brief overview of the presentation. It's going to cover the NASW guidelines, which are based on legal and ethical considerations. It will also cover the California Board of Behavioral Sciences licensing regulations, which cover licensed clinical social workers, licensed marriage family therapists, and the new licensed professional clinical counselor license. Other California applicable legal guidelines or regulations will also be considered. The NASW guidelines start with the Code of Ethics. I'm going to quote from the Code of Ethics. Social workers should store records following termination of services to ensure reasonable future access. Records should also be maintained for the number of years as required by state statutes or relevant contracts. The clinician could receive a client-signed release for records. Since there are no records, the clinician could not provide the records to that client. The client could then perhaps sue for emotional or other harm due to the deprivation of access or denial of access to their mental health records. Another common example is the client is in litigation with her employer and seeks to access her mental health records. The clinician had destroyed her records after service was terminated. The client could then claim that the destruction of her records had harmed her or damaged her.